Okay, good afternoon, everybody. I see people trickling in. I'm going to give a general welcome to everybody to the BEDC. We're doing the winding down. Obviously, you signed up for it, so you know what you're here, why you're here, and what you're going to learn. So we got 11 people in. Welcome, everybody. We have a special treat. So if you came on to listen about and be educated about winding down your business for whatever reason, because it's multiple reasons, then you came to the right place. We have 4 outstandingly amazing presenters. Gonna blow your socks off. We got first we've got coming up Deloitte. We have Robert Cowie and Marthinus Dreyer. Did I get it good enough? Sorry.
Great.
Terrible with names. You can beat me up later. Then we have Spencer West, company Spencer West, and we have Orchid and Heidi Roque. Yes, so a star-studded group. You get autographs later. So, I mean, without further ado, let's rock and roll. So up first, we've got Deloitte, Robert and Marthinus.
Hi. Thank you. Thanks for the introduction, and thanks very much for having us here. Just popping up the slides now. So, let's just check. Can you see those? Can you see our first slide?
Looks good.
Perfect. Yeah, thanks very much for having us. So, as you said, I'm Robert, and this is Marthinus. We're both from Deloitte, and we both work in the restructuring department here in Bermuda. And yeah, we're going to sort of talk to you briefly about the different options that are available. You know, when you want to wind down a company for whatever reason. Yeah, as you mentioned, there's a variety of reasons why you may want to wind down your business. It's not always doom and gloom. It's not always because business is going bad. You know, it can be because you have sold your business and then need to wind down the vehicle which you've been doing the business in. It could be you've been working hard your whole life and now in the position where you're looking to retire. So there's many different reasons, why you may need to wind down your business. But in essence, really, you just have to be aware of the responsibilities you have as a business owner, someone running a business, before you're in a position to strike your business up or to close down your business.
Great. Thanks, Rob. Yes, it's like talking about your favorite sports team losing. It's not great, but we will have to do it. So it's not all doom and gloom. I'm going to start the session, and then Robert will filter in. We're going to talk about 2 processes we are very familiar with, being members voluntary liquidations and then creditors liquidation. But before we start with that, the title of this section is Winding Down and How to Properly Close Your Business. Now, we didn't even prepare a slide on it, and me and Robert discussed it this morning. They said, well, but it is good for everybody on this call, on this webinar, to know there is a process that the government provides for, and there's actually a very handy form on the government website. If you just Google the terms application for voluntary strike-off in Bermuda, you will get a form that's in terms of section 261A of the Companies Act, and the form that you get there is a form asking you to confirm certain factors and facts about your business. Now, that's it when you are in the process of giving up your business, and this is on giving up a solvent business. So you had a company that functioned properly due to age or due to the fact that you have a new business opportunity, or maybe engage on a new level with another employer. You want to stop stop your business, there's a very simple form with a text box format, and it will ask you stuff to confirm. And I will quickly run through the list. The first one, and this is general principles, and in all circumstances where you want to stop doing business, is they will ask you to confirm that you actually stop trading. They will ask you to confirm that you notified everybody that's involved. That's all the involved parties. That is all creditors. That's all debtors. That's all service providers. They will ask you to confirm that all your tax filings and all your other regulatory fees and fines and all other payments are paid up to date, and nothing is outstanding. That you squared up with all regulators and notified all regulators, should there be regulators or government bodies involved. That you notified the bank, that you closed all your bank accounts, that there's no company liabilities, that there's no court proceedings going, that there's no active summonses, or as I mentioned, court proceedings. They actually have it in two lists. So no active court proceedings and no outstanding summonses against you. And they will ask you to confirm a list of the involved members or directors. And that's all things you need to confirm to say, well, we've checked everything. There's no legacy disadvantage to any creditors or to anybody involved in this company. And that safeguards you to against further action later down the line, and just a way for you to wrap up this company in a nice packet or pocket and say, well, I'm done now, I'm out, I notified everybody. Guys can't come 2 or 3 years down the line. There's, as always, there's exceptions, but chase me. And then you can have peace of mind and go on with your new business endeavors. Rob, I don't know if you have anything more to comment or want to step into more of the liquidation proceedings.
Yeah, just to touch on a bit more of that. These are some things. Sometimes, when you're coming to the end of a business, it's easy just to shut up shop and get on with things. But yeah, it's these sorts of statutory requirements which, if you take the time to do these properly, then it can save yourself a big headache down the line. Potentially, if you just didn't go through the formal processes of getting a company struck off the register, for example, it leaves it open for fines on not keeping up with statutory requirements and things like that. So that sort of leads us into the first form of a voluntary liquidation, which Tim's mentioned, which is a members' voluntary liquidation. And this is where you have a solvent company and you want to appoint a third-party professional to assist with the formal winding down. So essentially, all of the things that Tim has mentioned were prerequisites for a company to be struck off the register of companies. You can appoint either an attorney in Bermuda or an insolvency practitioner, for example, to oversee all of that, make sure all of those things are done, make sure all those statutory requirements have been complied with prior to the company getting struck off the register. So members' voluntary liquidation is a process which is initiated by the company. It's initiated first by the directors, and then appointment of this third-party professional would be ratified by the shareholders at a board meeting and members' meetings. The process could be very quick. It does require the directors to confirm that the company is solvent by way of a declaration of solvency, and then which essentially just says that the company is able to pay all of its debts within the next 12 months or so. Or 12 months is the sort of ceiling for that period. The whole process, following the appointment, does depend on circumstances, but if a business is cease trading and it's just a case of going to do the procedural processes, then you're looking at sort of 8 to 12 weeks process. Sort of 3 months is sort of the expected time frame on that. And the reason why you might want to do an NVL rather than just go through the striking off procedure that Marthinus was talking about earlier, where just do go on get the government form and certify that you've completed all these requirements. It could be that you want the support from an independent third party to make sure that that there's going to be no opportunities for any of these things to be contested or scrutinised on. It may be that you have been running a company with partners that are no longer, and that partnership is sort of sour, and is no longer amicable, and you need that sort of third party to divide up the assets and distribute the assets of the company at the end of the business fairly and properly. So there's a number of reasons why that might be preferable to directors and shareholders. And I'll pass it back to Marthinus now. So just to talk about the other process which we mentioned earlier, which is a creditor's voluntary liquidation. And this is the distinction here is this is a process that a director may need to consider if the company is not solvent and the directors are unwilling or unable to sign a statutory declaration of solvency.
Great, thanks, Roque. Yes, so in short, it's a creditor's voluntary liquidation. It's also a process that's out of court for the most part, but in this circumstances, it is where your company is insolvent. So where you can't sign, as Roque pointed out, where you can't sign a declaration of solvency, and you got to a point where you need to wind up the company and pay some dividends to certain creditors. Again, it started by the directors and shareholders, but it's always ratified by the creditors, and the creditors will vote on a creditors meeting. It's a little more intense, but as you can imagine, the moment that you start paying people a percentage in the dollar, 50% or 80% or even 90%, it's a little more contentious process, and there's a lot of legalese involved, and their advice will be to look at insolvency practitioner or a lawyer to assist you in that process. But it is a process that can make the whole winding up system quick, easy, and help you to get out of it as good as possible. And this is the bad part to talk about if you talk about a situation where you can't pay all your creditors and can't pay all your debtors, and you need to compromise. But although this is a bad part of business to address, it's something that cannot be left unattended. You don't want to be in a situation, and I know in this situation we are focusing more on smaller entities, but you don't want to be in a situation where you were supposed to do a creditor's voluntary wind up, or for that matter, a member's voluntary liquidation, and you failed to do it. I recently dealt with a situation where the company just left it and they decided, well, we're not going to do anything. Unfortunately, they were involved with, well, fortunately or unfortunately, they were involved with a lot of the regulatory agencies, the BMA, the ROC, and there were certain fines and penalties that they were supposed to be paying and should have paid for doing business in Bermuda, which they didn't. And where it would have been a cheap, relatively quick, inexpensive process, if they did it correctly from the start, one of the involved parties was forced to do a court application to liquidate these guys, and then it became extremely expensive. So it's always better to look at the quicker, cheaper options. And the general note on that is to keep your company's affairs in order, to keep accurate books and record and accounting systems in regards to how the setup looks and what happened during the lifetime of your company. That is me on CDLs. I don't want to go much deeper. I don't know, Rob, if you have anything more to say on CDLs.
No, I think we can end our presentation there, and obviously very, very happy to take any questions following Orchid and Heidi.
Okay, that brings me back. Thank you, guys. That was a lot of good, edifying information, I'm sure, for our audience. I appreciate it, 100%. So we're going to save questions to the end. I'm going to remind you guys, our audience, our great participants, to, you can throw some questions to us in the question box that you should have. Please do that, and I can then we'll have those questions answered at the end. So now we're going to move over to Spencer West. We have Orchid again and Heidi. Heidi, take it away, and Orchid.
Orchid first. Okay, thanks a lot, Donte, for that wonderful introduction. I do feel the pressure's on a little bit, but thank you so much for your generous compliments. And thank you to Deloitte for that wonderful presentation. Certainly raised the bar. And so I'd like to start off by playing a short video. It's only 2 minutes long, on the importance of making the wills, or making your will. My area of expertise is trust and estates. So really, my emphasis on my presentation will be to enlighten, to reinforce, to explain to you the importance of succession planning through your estate planning, especially in relation to winding up your businesses when it comes to business affairs. So we'll start by playing the short video, and then I will speak briefly on what I just said, and then I'll hand it over to Heidi, who will speak from a corporate legal perspective on winding up.
Hi, my name is Orchid Lee. Let's talk about the importance of making your will. Some people delay making a will because they think, now's not the time, I'm too busy, or maybe I'm not married yet, or I don't have enough assets. The truth is none of these are good reasons for not making the most important and essential document you should have. I've been in the legal profession for over 19 years, and I've seen the devastation that happens when someone dies without a will. If you die without a will, also known as intestate, the law dictates what happens to all your assets, which may not be what you would have wanted. Making a will helps to avoid the rules of intestacy, appoint guardians, distribute your assets as you wish, and make funeral arrangements. Most important is the peace of mind that you get when you make your will. Let me share a true story about one of my clients. Carl had a daughter from a previous relationship. He later married and had 2 sons. He made a will at this point in time. The will made provisions for the boys, but nothing for his daughter. Following his divorce, he planned to amend his will to include his daughter, but unfortunately, he died before he was able to do this. My advice? Make your will today. Do not procrastinate, because tomorrow is not promised. Making a will avoids many heartaches, especially if you have close friends, children from a previous union, stepchildren, or unadopted children who you would want to benefit. They are not likely to receive anything under intestacy. For a free consultation on making your will, contact me at orchid.lee@spencer-west.com or call 441-532-7735. Don't delay. Make your will today.
That really is just to drive home just how important it is to make sure that you have a will when you have a business in particular, because in the same token that wills are used for succession as far as your estates, part of your estates would be your business, and ensuring that you know, the next generation or the right appointed person is actually put in place in relation to that asset, which would be your business. I mean, let's face it, you know, we as individuals, entrepreneurs, what have you, work very hard to build the business during our lifetime. And so it's always good to make sure that there's provisions put in place for the next event. I did make a video on the importance of making your will, and I wish I also had a video on the importance of making your trust, because a trust is also an instrument that can be used in relation to succession planning during your lifetime, as well as after your lifetime. So, and trust can be used for so many things, which is why it's very difficult to make a short video on how a trust can be used as far as, you know, when a company has been wound up. The trust can speak to, you know, who should hold the shares. Equally, the will could do that as well. Who should manage the company, and equally a will or a trust could do that as well. What I've seen quite a lot in my profession, as far as trusts are concerned, if you have a business you're in the process of winding up the company, but the company is not particularly very liquid, or it's not liquid because it has toxic assets in it that make it difficult to wind up the company. What a lot of business persons or individuals will do is they will transfer that asset or put that asset into a trust so that the trust can hold the asset, and they can get that asset off of their books, off their balance sheets, so they can continue with winding down the company itself. So that's one of the very brilliant ways that trusts can be used when you're winding up a company. Again, like I said, it can be used to deal with illiquid or toxic companies, and also it can be used as a mechanism for sort of dictating how you want the company to be managed going forward. And so those are two key aspects of wills and trusts. Another thing that I've seen recently with estate planning, when it comes to you know, the winding up of your company, is the use of it to say, should something happen to me, I want my company to be used for charitable purposes or for whatever purpose. So you can also do that as well. I won't go into too much detail because you know, there's a lot that could be said as far as that, but just the main takeaway for me is for you to understand that succession planning in relation to your company during the winding down process, and even after the winding up process, is an important thing to bear in mind going forward. And now I'll turn it over to Heidi.
All right, thanks, Orchid. Thank you. Afternoon, everybody.
Can't hear you, Heidi. Heidi, I
hear me?
can't hear you. Okay, now I can hear you.
Okay. I'm not sure how far that got into, but good afternoon. My name is Heidi Roque. I'm a corporate lawyer. I've been a corporate lawyer for 13 years. I'm with Spencer West Bermuda. Thank you, Robert and Martinez, for that great presentation. I'm going to add a little bit about the members' voluntary liquidation side from sort of a corporate aspect from what I've seen in practice in my 13 years. Just a little bit really quickly about the advantages to doing also a member's voluntary liquidation versus the strike off. With a strike off, it's great that they've now got, the RSC has a way and a process of making sure that people are paying off its debts before the company is actually struck off, because one of the issues that we had previously was not just that it wasn't paying its creditors, but also sometimes the company would have assets still in it. And what happens is once the company gets struck off, those assets become what's called bona vacantia, becomes the property of the Bermuda government, which I'm sure you would not want to happen to your hard-earned money or property if the company owns any assets overseas, whatever may be the case. And in order to be able to get access to those assets again, you'd actually have to go through a process through the Supreme Court of Bermuda, what's called a reinstatement. And that could take, several months. It could be very costly depending on how long the company has been struck off for, because you'd have to pay back all of the previous annual government fees, any outstanding fees to the Bermuda government that may be owed to the registrar of companies, and late fees. And then you'd be able to go through that process. You'd have to pay a lawyer for it to get that all done. So you'd be paying out on legal fees as well. And that could take several months, like I said, in order for you to be able to get access to those assets to be able to do whatever it is you need to do with it. With respect to a member's voluntary liquidation, again, as Robert and Martinez said, this is when a company is solvent. So it has enough assets or cash in order to be able to make sure that all of its creditors and its debts are being paid. Really great if there's some extra cash left over in order to be able to pay out to the shareholders after, but not necessarily always the case. Ideally, in practice, what we would normally do, the directors and the shareholders have to agree to liquidate the company. They can be done by either a physical meeting, or it can be done by what's called a written resolution. Either way, the board and the shareholders would agree to liquidate the company, and they also agree who is going to be appointed as the liquidator. Then what happens is there are notices that are filed in the Royal Gazette, which again state the company is going into liquidation. We're appointing this particular person as the liquidator. The creditors are notified in one of those notices to say you have 14 days, so you have this particular date by which to bring forward any claim you may have against the company. So if we owe you any money, you have those 14 days in order to be able to let us know about it so that we can make sure that you're getting paid. Once those notices are published, documents are then filed with the registrar of companies to advise who is being appointed as the liquidator, to advise that at one point after the 14 days have gone by, that no creditors have come in to say that they're owed any funds. Ideally, what we try to do, or what I've tried to do with my clients, is I do written resolutions. Everything is all kind of set and ready to go. So once the legal notices are published, we can file everything right away. That kind of makes sure that the process is more efficient. So you have everything in place to go up and get filed as soon as possible. And then what happens is after the date of the publication of the legal notices in the Royal Gazette, there is 30 days that have to be you have to wait 30 days, and then there is a shareholders meeting, which then finalizes the whole liquidation process. Now, you have to keep in mind as well, depending on how many assets or how many liabilities and creditors the company may have, the process ideally would take 6 to 8 weeks. But if there are long tail assets or long tail creditors that have to be paid, it could take longer. And then, of course, your liquidation fees would obviously be longer. The longer it would be more expensive, the longer it takes in order to be able to shut the company down formally in that way. But ideally, 6 to 8 weeks is a great spot. to have it cut off, to have everything finalized, because then you know what's going on, what day it's going to be all finished and finalized, and then you know that you can, you've shut everything down properly, all your assets have been distributed properly, all your creditors have been paid, and everybody is happy. So thanks again for having me, and I hope that this information was useful to all of you.
Okay. I think that was very useful. And I see some questions that we already had when we started. I do want to say, not seeing or being able to hear people in this form is awesomely strange. But that said, guys, give me some questions. You must have questions. I don't see any questions. Give me some questions. I will give some questions that I have been given. Let me see here. Yet. Well, the first one, I think you just answered, Heidi. How long does the process usually take? You know, usually, well, maybe I can answer it. That's like asking how long is a piece of string, it sounds like. Because it depends, you know, how, you know, you got to sell your assets and blah, blah, blah. So 6 to 8 weeks is probably what you're looking at, or you would want. Is that the answer, Heidi?
Ideally, usually, if there's not a lot of assets, or if the assets are liquid, so if it's cash or something that you can sell really easily, but if it's something like property, that may take, especially if it's a, you know, a big property worth a lot of money, say millions and millions of dollars, that could potentially take months to find a buyer and then to complete the sale. So that, you know, could take another 6 months added on to the time that it would take in order to be able to finalize liquidation, because you'd have to sell that property, deal with the conveyance, get the money in, and then that would all then have to be distributed to all the shareholders, or if there's still any creditors at that point, pay off all of the creditors, and then distribute the rest of the cash out to the shareholders after that.
Okay.
And this is where having a trust can sometimes assist clients, you know, where there's particular assets that are difficult to liquidate, or, you know, it might take like, you know, years for it to be dealt with. Having a trust can help them in those situations as well, while trying to, you know, get the asset to become liquid. And sometimes it's almost impossible to get some assets to become liquid. I mean.
Yeah, if you've got shares, for instance, you know, and you can't sell them, you have to be able to get them out of the company somehow. So if you transfer it over to the trust, then you can transfer it out of the company so that you can make sure that you can then continue with the liquidation process.
Or you can, a lot of those things can be sorted before you make the appointment of a liquidator if you're worried about the time of the liquidation period. So, I mean, it's always good to advise that, you know, where, as far as possible, that all your creditors are paid down. There's no point bringing them into the liquidation process if you can avoid that. Yeah, some good advice about transferring out assets as well. You know, if you're looking at distributing sort of non-cash assets as well, that can also be done in a liquidation as well. So you can have distribution of specie. So if you couldn't sell some problem shares, or for example, they could be valued agreed by the shareholders, and they could be distributed to shareholders in specie. So you don't have to just distribute cash. So I suppose similarly, if you had a property and only one shareholder, that again, you know, those could be distributed out of a company into the shareholder's name if they're proven problematic to realise, and you want to continue with the wind down of a company. So I mean, that, as you were saying, Donte, these things, how long's a piece of string? There's so many different sort of circumstances that people could face in businesses. You know, lots of unique elements, but you know, but there's normally practical solutions to all of these things that Orchid and Heidi and myself and Marthinus will have seen. You know, lots of problems, and you know, it's always good fun to work with people to resolve those. So yeah, but.
One comment, and Heidi, thank you so much for the presentation on MBLs and Lee on wills. You made me think about my own wills, so thank you for that. But one thing, and Heidi will probably agree with us, is the thing is to keep if you're looking at a time period to do a liquidation, despite shares and properties and all that things that we will know that can slow it down, but if you keep your affairs in order and you provide Heidi with your affairs and well-documented books and records, it makes it a lot easier. And it makes 8 weeks possible. But if we need to start searching for evidence and proof and documentation, then it can. How long is this piece of string?
Yeah, very true.
This is interesting because I feel this way. Obviously, at the BEDC, Bermuda Economic Development Corporation, we deal with entrepreneurs all the time, and so succession planning or planning the ending of I shouldn't use those two terms together, but planning the ending of your business should come not towards the end of your business, but actually it should be somewhere at the beginning or in the middle. What happens to a lot of entrepreneurs is that you get stuck in the day-to-day operations, right? And so, before you know it, you've missed a lot of time to do this planning. And what do I mean by that? Well, back to the term that I said initially, succession planning should be there at the forefront, where you can potentially sit down with a Heidi or Orchid or I mean, Robert and Tejas, do people sit down with you? Do they come to see you as well?
Yeah, absolutely. Yeah, we have calls, and we can take consultations to advise on the best course of action. We're always happy to assist people with these sort of queries. Absolutely.
And so what I'm trying to get at, and I'm not sure how well I'm doing it, but what I'm trying to get at is that it's similar to we talked about the will. Or trust, you do that prior to you dying, but you sit down and you sort of manage your business aspects that are not day to day and are not necessarily giving you revenue. And I know it's hard to do because you're thinking, I don't have much time anyway. So you're telling me I'm going to spend money, sit down with a lawyer, figure out how I can manage things way down the line. And it comes at an expense. But the answer is, I don't know, Heidi, do you think individuals should be doing that at the outset of their business? When I say that, succession planning, thinking about a trust, they may not even know what a trust is, but they should probably sit down with a lawyer or you guys, any one of you, and say, well, look, this is my business. We're doing pretty good. I don't know what I don't know, but I kind of know what I would like in the future. And then you can give them a whole host of stuff to do. Potentially.
Yeah, if you don't mind, I can speak to that as well. And really, it's great to think, it's going to be way down the line. But the truth of the matter is that nobody can predict the future, right? So anything can happen at any point in time. So you want to make sure that you have these things in place from the onset, like you rightly pointed out, Donte, because as Benjamin Franklin wisely said, the only two certainties in life is death and taxes, right? So and we don't know when at any point in time that can happen. So yes, you want to plan for way down the line, but you want to do it sooner rather than later. You want to do it from the onset in the case of any sort of eventuality that can happen at any point in time. And at least if you have those things in place, then you don't have to worry. That's why my video very much says, then you can have peace of mind at any point in time that should something happen, your business won't suffer as a result because you've already put all the things in place that need to be in place should something ever happen. And at least you can have, that solace and that reassurance that, should something happen, this is how you want the business to be managed. This is how you would like the succession to go with respect to your business. This is who should take over the management of that business. This is who I would like to resume this particular role. You know, like you can actually put those things in place, and you can be very strategic about your wishes, because the thing is, as entrepreneurs, and business people, we already have a strong sense of succession and who we want to sort of turn the baton over to, you know, or to groom for a particular role, to move into a particular space. But should something happen to us, we go with that knowledge, you know, and unless you sort of pass that knowledge on in writing, and it's actually in a document that your successors will have to follow, then that's the only way that you can sort of guarantee that your wishes will be respected and will be honored. It's one thing to say, oh, well, my family knows, or my manager knows what I want. Well, that's just simply not, you know, as we all know, not good enough. You need to have something in writing. You have to have the correct documentation in place to ensure that that actually happens.
I mean, at the end of the day, too, if you think about it with the trust and succession planning and having a will, if you don't have a will, even though you may have said to your family, I want this, this, and this to happen to, say, the shares in my company, the government and the law doesn't care what you want. It's true.
It's true. It's true. Because what happens if you don't say what's going to happen to your shares and you die without a will, then you die in what's known as intestacy. And the law, the succession law, dictates exactly how that succession goes. And it may not be what your wishes would be. So, for example, you know, your assets, if you were married, will go to your spouse. If you had children, it would go to your spouse and your children, and so on and so forth. And the law dictates exactly what happens to those assets. And again, you may not necessarily want your spouse to have your shares, or have, you know, or to manage your business. You may actually want someone else to do that. So it's great to make sure that you put those things in place sooner rather than later, in any eventuality.
Excellent. As time winds down, I think we're at 1:30. We got 15 minutes left. The big question I have, because nobody seems to want to ask questions, I'll ask a question, because I feel like everybody wants to know this. Cost, price, cost. Okay, so now let me preface that with saying, those of you who attended this session, we have four professionals, lawyers who know. Are you guys? No, Robert, you guys not lawyers. These guys are finance gurus. And you know what? They probably charge per hour, and you're getting an hour free with four amazing professionals. So count yourself lucky. But the question I have is, you know what? So I don't know what I don't know. I heard this. It sounds interesting. Do I need a trust? Do I need a will? I got to figure out what winding down looks like. I know the stage. All these questions are going in my mind, and I'm probably thinking now I need to sit down with one of these guys, right? But there's a big but. Oh no, they're going to take my fingernails, my knee bones, and everything else. So give me, you know, what does it look like? Do you have an initial sit down, free, or discount? I don't know what it looks like in terms of cost. What happens?
Yeah, well, for us, we're always happy to take initial consultations and sort of provide, you know, provide some advice on whether we'd be able to assist or not. Sometimes we'll have inquiries and it will turn out that, you know, actually, you know, our services won't be required. But you know, so for those initial discussions, yeah, we're always happy to sit down with people, you know, at no cost initially, just to see to see what their problems are, see if we'd be able to assist. If it looks like it's something that we'd be able to help out with, then we look at drawing up a formal engagement. We can't act on anything without being properly engaged, provide the clients with proper terms and conditions, etc. Set out our responsibilities to them and the company. Yeah, so it's just very important to set out all that legally, because when you're winding down a business, there's different parties here. You've got the directors, and then you've got the shareholders, and then if it's an insolvent liquidation, you've got the creditors. So at the outset, you just need to be very clear about setting out our responsibilities to those different parties. You have different objectives and different concerns throughout that process. So yeah, and it's at that stage when we discuss what sort of the cost of the process would be, and as we've discovered on this webinar, there's lots of different eventualities. There's lots of different timescales that could exist, and obviously, as you say, we do charge by the hour. That's how fees are incurred here. But obviously on some of the smaller assignments, there can be discussions on sort of fixed fee basis for a simple winding down, for example. But yeah, it's hard, as you say, just to put a number on a figure there, but it does depend on all of the circumstances.
So from my side, I'm actually an attorney as well. I don't know what I'm doing in the FA space. No, I saw the light, Heidi, and now I'm working in the financial advisory space. But just to add to that, from a wills and trust aspect, we are, both me and Robert are more insolvency experts and working as insolvency practitioners. So I think in that space, please, Lee and Heidi know what they are doing, and they are more than competent from this call, at least that I can see, to address your questions there. So
okay.
Yeah, and just I did mention at the end of the video that the first hour of consultation is free. So that's kind of where we stand as far as our initial consultation with our clients.
Is that enough time? Sorry,
we welcome.
You sort of see the whole picture that first hour.
Yeah. Usually we're able to get you to where you need to be within an hour. If it's longer than an hour, then chances are your matter is quite complex, which again, getting the first hour of free is still very cost effective, I would say, for getting the sort of legal high level legal advice that you'll get once you meet with myself and or Heidi. So
okay, great.
that's generally how we do it.
To do like the members voluntary liquidation on the corporate side, we would do something similar. We would get an engagement letter that would be signed by the directors of the company to bring you on as a client first. And then again, like Robert and Marthinus said, that sets out what our responsibilities are, what we're doing for you in terms of we're liquidating the company and going through that whole process. We would generally give you I'm trying to think of the word now.
An estimate.
We would give you an estimate of how much it would cost as sort of an initial fee. If we sort of get through the process and it's taking a lot longer than expected, there are assets that come up out of the woodworks that maybe the shareholder forgot about or the directors forgot about, that kind of came to light during that process. And then, again, if it's long tail assets where it's going to take longer potentially to get rid of them, sell it off, get the cash in, it would end up being charged probably on an hourly rate, or we would work out a higher fee. We would obviously get our retainer first for the fees, so that because we would then be a creditor of the company at that point once we take them on as a client, and we have to make sure that we get paid as well. So, so we would get a retainer, which means that we would get you to pay in the estimated fee in advance before we start any work. And then as we go along, like we said, hopefully, ideally, all of the assets and the liabilities have already been dealt with prior to coming to us. So there wouldn't be much of an issue with the fees going forward. It wouldn't be much extra or unexpected fees wouldn't come up. So the retainer ideally would cover that whole amount that we had agreed, and then we can shut the company down as soon as possible without any complications, ideally.
Yeah, and I mean, so Heidi spoke to the, the corporate side of things, and for as far as what I do with drafting a will or a trust, getting you set up with that, it's a very similar process where you sign an engagement letter. I will provide you with a fee quote depending on our conversation, and we do have an hourly rate, myself and Heidi, that we charge. But usually we stick within the cost estimate. And if things become a little bit more complex, then we go over. But generally, we try to keep our clients informed of the status, or they can be informed of the status if they ask.
Yeah.
But that's usually the process.
And so that's great to hear. You're transparent. They can come get some free sort of a free consultation. From there, they get an understanding of the cost, and they can pick, choose, and refuse depending on which direction they go. That's great. So yeah, we're winding down here. We've got 5 minutes left. I don't see any questions. So what's the difference? You talked about trust. You use trust and will together. What's the difference in cost? Is there a cost difference, or does one take longer? Why would one? I mean, this 5 minutes. Maybe I'm entering into another segment, another hour of stuff.
Another webinar on that if you want.
Yeah, and that's why I kind of just kept things on the surface, because a will or a trust can be, can be very basic, and it can be extremely complex, how depending on the client's needs. So it's very difficult to say exactly how much it would cost until I've actually spoken to the client and get a better understanding of what the client needs, and then I'm able to give a more accurate quote. So I'm sorry that it's kind of the shoestring situation again. How long is a shoestring? It's very difficult to say.
There you go. There you go.
Yeah.
Okay. We got 3 minutes. I guess we finished a little early. Any parting words aside from goodbye? Otherwise, it could be a goodbye, and thank you very much. But any parting words?
Just thank you, Donte, for having us here. It's been great to speak with Orchid and Heidi here. Very enjoyable. I just want to say, presumably, if any of the guys listening wants to reach out to myself or Marthinus there, you could pass on our details for people to do that. That'd be great. Yeah, I'm happy to answer any questions people have following this webinar. But thanks for having us.
And from my side, keep your affairs in order, because that will save time and cost.
Yeah, that's a big
Yes,
one.
and I echo Robert's and Marthinus' comments, as well as Heidi's, and thank you, Donte, for being a fabulous moderator. And just to say that if anyone would like to speak with myself and or Heidi, please do reach out to us. We're very amenable to hearing from you, and look forward to speaking with you, and also to speaking with you again, Robert and Martha.
That'd be great. Thanks.
I think everything has already been said. So, but yes, thank you for having us. I appreciate you allowing us to come on today and kind of give our sort of our our advice to your members to kind of like get them sort of thinking about things that they should be thinking about now rather than waiting until it's too late. So definitely suggest, I have my will in place, just so you know. So yes, thank you very much. And I wish you all a very happy rest of your day and weekend.
Guys, all of you, thank you so much from the BEDC. We appreciate your time. I know you're very busy. You're always welcome. And if you ever say, well, look, we've got a new product, or we want to speak out, or we want to say anything about what you guys are doing, you're always welcome here in this forum. Give us a call. Otherwise, we're going to find you at some point to bring you back on. So thank you so much. Appreciate you guys. Have a great day.
You too.
Bye-bye. See you soon.